Now he is.
Right, that's why I said it.
Oh, okay, yeah.
Sir, with the too short name, what is your name, sir? Why did it take you so long to get connected to audio?
I don't know how to do it.
Sure. Yeah, that makes sense.
Yeah, there you go.
Okay, I got it now. Can you hear me?
Yes, that's why I'm talking to you.
Okay. My name Delco Thomas.
Okay, thank you, Mr. Delco Thomas. We'll put you on a list of cases to be called. We're on a breakout session right now. We have to wait till the prosecutor returns. He's in a breakout room.
Okay.
Three 35404 and 35447. Y'all give me just a second. I'm going through these letters real quick. Have you had an opportunity to review those letters also, Ms. Martino? All right, you are Dynasty White, and Ms. White was previously in court. Entered pleas of truth accounts 1, 2, and 4 in a motion to revoke unadjudicated probation. I've received an updated pre-sentence report as well as some letters on her behalf. I've reviewed all of that. Has everyone had an opportunity to review those things?
Yeah.
Are there any additions or corrections to that pre-sentence report?
No, from the first.
All right, Mr. Lewis, you may proceed.
Judge, I think the biggest issue with Ms. White was her not having support, adequate support, from her, with a family or close friends that to help her with the situation. A lot of time probation is hard enough, just trying to get through it yourself. But then once you have a child that's ill, it becomes even harder. And I think that's one of the biggest issues that Ms. White was dealing with, was that trying to accommodate the care for her child at the same time complying with probation, which, that's what caused a lot of the issues with the not reporting and things of that nature. I think the child spent a significant amount of time in the hospital outside of Jefferson County, I believe in Louisiana at one point for a long period of time, which caused a lot of those issues, which she constantly, according to probation, she did let them know about what's going on with the child. Even in February, a travel clearance was given to her in February so she could travel with her child. A couple months later, she was there, the administrative hearing happened a couple months later, I think in May. And even after that, of course, it still was hard for her trying to make that travel, 5, 6 hours away, going through this without support. The one good thing that's happened since she's been in custody that you see from the letters that people have stepped up to be able to be there for and help her get through this, to where if she's allowed to continue on supervision, I think she'll be able to comply, keep up with the conditions of probation, as well as be there for a child. I think now that she does have that stable environment, unfortunately, it took her for her being in custody for this to happen. But now that she has this, I think she has has definitely got her more focused on being able to complete her responsibilities. So we're asking that the court consider to continue her on supervision.
Ms. Malfino?
Judge, obviously the concern of the state is the fact that the administrative hearing and the updated PSI both reflect the issues with her attitude in respect to the probation department trying to bend over backwards to assist her in all of those different things that she's dealing with. Certainly appreciate the fact that she doesn't have felony criminal history in this would be 2 felony convictions, so I would defer to whatever you think is appropriate, Judge, but I think that maybe she needs some zero tolerance or just a little bit of an attitude adjustment.
So, Ms. White, you're in court today. You're being cordial. You have the appropriate facial expressions when Mr. Lewis is talking about you and what you want to do. But that's not the picture I'm getting, and that's not how you act, apparently, when you're in front of probation. So that's a big problem. You don't get to act one way to your probation officer and then come in here and go, I want to be a mom and I want to be with my kids and I'm so great and I've got all these things, and then go in there and be disrespectful to the people who are trying to help you. You understand that? They are not there for you to be disrespectful to, ugly to. I mean, they're just trying to do their job, and their job is actually to try to help you, which is looks like what they tried to do. They got you the travel permit. They've rescheduled your appointments. They are trying to help you, and you're going to treat them that way, and then come in and want me to be nice to you when you're not doing that to them. So if I give you this opportunity today, you have to understand that you don't get to just come into court and act respectful. You have to act respectful in every part of your life. In your job, you got to get a job, to your probation officer. Otherwise, you're going to go to prison for up to 20 years. 20 years. I could send you to prison right now. Right? How long have you been in custody on this MTRP? 90 days. How old are you? 23 years old. 2 kids, looking at going to prison for 20 years. Now, when you first got this case, I would be saying, you know what? You're young. Give you, talking to you about, you're still young, but you're not a baby anymore. It is time for you to grow up so that you can be a parent. And sometimes that's hard, and it's making decisions that are different than the decisions you've made previously in your life, right? Okay, so I'm going to give you an opportunity today, but I want you to understand that you will not be given this opportunity in front of me again. I want you to take advantage of it. I want you to be there to take care of your children. I really do want that. I want you to be successful. You don't have a felony conviction. You can still do all kinds of things with your life, all kinds of things, whatever you want, because you don't have a felony conviction, right? And that's what we all want. I want you to succeed. I really do. So I'm going to find that you entered your pleas of true to counts 1, 2, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation and find you guilty, but I'm not going to do that. I'm going to allow that 90 days sitting in jail to serve as a sanction. Hopefully it really was kind of an eye-opening experience. You don't want to be there. You don't want to be in prison. So take heart of that. Don't forget what it felt like. Okay. Don't get out and in 6 months or a year, forget what it feels like right now. Remember what it feels like. And then if you're thinking about doing something you shouldn't, or not showing up, or not, think about how it feels. Okay. And make those better decisions. So what'll happen, the first thing when you're released, you'll need to go get with your probation officer, figure out, I understand you have a child that has some special needs and has been sick, but you can't help them for sure if you're in prison. So you have, all these people are saying they're going to help you. Hopefully they really will, because you're going to have to come for your appointments regardless of what's going on in your life. This has to be a priority, sometimes even over that. Okay, even if it's just for a day, probation has to take priority over your child. Otherwise, prison will take priority, and that's not what we want. Does that make sense? Okay, all right, you can go back with the bailiff. Good luck.
And I believe the defendant does not speak fluent English, so we have a translator. Thank you, sir, for being here. And raise your right hand. Do you solemnly swear or affirm that you will translate from English to Spanish, the language that Mr. Galvez understands and is fluent in? You will repeat his statements verbatim from Spanish and translated into English so all of us and the court reporter can take that down. And will you do that to the best of your knowledge, sir, and accurately, so help you God?
I will.
All right. And Mr. Galvez, has he been sworn in?
He was previously judged.
All right.
Sentencing.
Okay. In this case, Mr. Galvez has previously pleaded guilty to the second-degree felony of indecency with a child. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to the pre-sentence report that has been prepared by the probation office?
On behalf of the defense, on page 2 at the bottom, the last entry under adult misdemeanor court history, it reflects an assault occurring the day after the offense that he's.
Okay,
before
that's
you.
pending. That has not been disposed of.
And he doesn't.
It will not be
he knows
considered.
what that- He's not sure what that is. Okay.
I will not consider that if it's a pending matter unless the parties want to put evidence on for me to find beyond a reasonable doubt that it exists. So the presumption of innocence exists and will be maintained on pending cases.
Okay, and then other than our responses or our comments that we would make regarding the recommendations that the probation officer made and the comments, we wouldn't really be correcting their comments, but would have some to just have some things to discuss when we get to that point.
State, any corrections or changes?
No, Your Honor.
Then the pre-sentence report is made a part of the record for all purposes. The agreement that's been reached is whatever sentence shall not exceed a cap of 10 years in prison. So the options here are confinement in prison, no less than 2 nor more than 10 years. Deferred or unadjudicated probation, I believe, can be assessed. Regular probation. Is regular probation an option under these circumstances?
I believe so, yes, sir. It's not a deadly weapon, so.
Yes, but it's under this.
Sir.
Let's just verify. This book is almost 1,000 pages long that has the rules of law in it that I'm looking at, and I've got to refer. I have not memorized everything here, but 42. Was it 42A is where
That's good.
probation, community supervision. Limitation on judge ordered. Article 42A.053, judge ordered community supervision does not apply to a defendant adjudged guilty of an offense under 2111 Penal Code, indecency with a child. So I can't. And this is 2111.
Yes, sir.
So regular probation is not an option, but deferred or unadjudicated probation is. We got to remember that.
Yes, sir. Thank you for catching that, Your Honor.
This, all right. So go ahead, defense may go first.
All right, Your Honor, of course, as you can imagine, with this being a cap agreement, the defendant, Mr. Galvez, is asking for the court to grant him probation. I'd like to address a few things in the pre-sentence report. See here. Most everything is, as we said, there were no objections or changes, is correct. But when we get to the recommendations, I have a few things I would like to say on his behalf.
Okay.
Now, just to give the court an understanding, when the probation report was, when the interview was held, it was in this same sort of scenario with an interpreter and a probation officer. So one of the things is, of course, it mentions on page 5 and the second line of recommendations that he has the possibility of facing a third deportation. His feeling is that he's hoping that he doesn't get deported. I recognize ICE has a hold on him, but he is hoping that he will survive that type of litigation.
Okay.
The second thing, a little further down, it says, although the defendant did not discuss the present case, which earlier she mentions that it's, his attorney had given him instructions not to discuss the facts of this case in particular. Although the defendant did not discuss the present case, it appeared the defendant had no remorse for his actions in the present case. I'm not sure, and he's not sure why she had that feeling that he didn't discuss this case, but he informs me that he feels terrible. I mean, this is not something that he does have remorse for. There's a lot of adjectives and things I could say that to describe how he feels. He'll have a chance to speak to you himself, but he does not believe that should not have been anything that he did in that interview that would make her feel like he didn't care anything about what was going on here or for that little girl. A little bit further down, it says that that's 1, 2, 3, 4 more lines down or so that he seemed to be more concerned about his future alcohol consumption. Again, he's not sure why she felt that way. He told her that he drank not every day, but maybe once or twice a week. He drank 12 to 24 packs of beer, but remember 12 packs to 24 packs once or twice a week. But he doesn't
At a time?
Huh?
At a time?
At a time?
No. 3, 4, maximum.
You would buy that many a week
Compraba el cartón con su pincel.
and then maybe, and then took a little while to drink them. Is that what you're saying?
Yes.
But nonetheless, he's not sure. He doesn't remember having any conversation with her that made it seem like he was like, and I asked him, I said, well, did she tell you that if you got probation, you wouldn't be able to drink? And he's like, no, we didn't have that kind of conversation. So he's not sure. He said it's possible. It could just be some miscommunication, but he doesn't remember saying anything that made it seem like he was concerned that he wouldn't be able to consume alcohol if he had probation. And then the fourth thing is, the next thing is at the bottom of that same paragraph, that the officer is in agreement with the proposed plea bargain, a 10-year cap, which I would interpret to mean that officer is okay with anywhere from probation to up to 10 years. So I take that as a positive comment. And I will say that I did not go over the supervision plan in the event the judge did allow him to have probation for the sake of time. But if the judge granted probation, I would ask that the interpreter be allowed to go over each of these 3.5 pages of 3 pages of rules.
That will be granted.
Yes, sir. Thank you. And so those are the comments I have about the different comments that were made in this report. This child who he harmed, that he recognizes he harmed, spoke up immediately. He was arrested. He took responsibility has not ever once with me indicated that somebody's trying to lie about him or make up things. He acknowledges what he did. He acknowledges that it was wrong. He knew it was wrong when it happened. He says he wasn't under the influence of any alcohol. Can't explain why he let himself do that. But he recognizes he's here where he is right now. He feels like the time that he's been in jail has given him a lot of time to reflect on his bad choice, bad behavior, and the effect it may have, it probably has on that child. But he is asking that the court allow him the chance to be out on probation on this case. He knows he'll have to attend different classes and things with regard to that type of behavior. He understands about registering, whether he gets probation or not. He said that he wants to come out and work, focus on being the best person he can. He's had time to think about his mistakes and recognizes what he needs to do to be a better person. Somebody commented somewhere in the reports that he had, after this had happened, he bragged on the phone to someone, and he says he does not remember having a phone conversation with anybody. He doesn't really remember even having a phone with them. He's not saying that somebody is lying about it. He doesn't remember that happening. And he tells me that he is very, very sorry for what he has done. So we would ask the court to consider probation for Mr. Galvez, even in spite of all the other issues he has with possible deportation. And I would just say, Your Honor, that if the court is not inclined to grant him probation, that on this 2 to 10 scale, we would ask that you consider something no more than 5 years. I know that he will be wanting to express to you his feelings about his behavior when the opportunity, when it's his turn.
Okay. Stay.
Yeah, I'm recommending 10 years. That's the cap. It will allow you to follow the agreement. The reason for that request is multiple. On page 2, the comment that council just went into, if you read down on the 3rd line, it's the victim here that said, and I'm reading from the 3rd line. She said, even after the defendant committed the act, he was overheard on the phone by the victim bragging to someone about what he did to the victim. So it wasn't anybody, it was the child. It was the child that said she heard him bragging about it. Mr. Galvez, although he admits to the conduct, he denies any penetration. The detective on this case is asking that the court not give him probation. She's asking that you give him a penitentiary sentence. And again, I feel like it's warranted. At the bottom of page 2, a highlight for the court that he was on probation for DWI whenever this offense was committed. He admits to being drunk, which is a violation of those terms of probation. He has previously been given probation before, which was revoked because he didn't follow it. And he clearly wasn't following these conditions at the time in which he commits this criminal offense, which shows by his own conduct, not the comments of counsel, that he is not worthy of probation because he can't follow the rules. We go to page 3, which indicates he can't follow the rules because he was removed from being here illegally in 2008. He was removed from being here in 2019. He's got a current ICE hold because he's here illegally, which Your Honor knows is a federal offense. I cover all that because he was properly admonished at the time in which he entered this plea of what the conditions are. So I agree with Ms. Lindley on page 5 that what we're dealing with here is an undocumented non-citizen who is subject to the 3rd deportation. In addition to violating his probation, he's got other charges pending in Robertson County, Tennessee. a different state from where we're at. I'm unfamiliar with what those charges are, but I certainly know that that means that he travels outside of this jurisdiction. Again, things that indicate he's not proper for probation. And I believe that the comment that the officer made about the agreement is that she's okay with the court assessing punishment up to 2 years. Not that she's suggesting in any form and or fashion that probation is appropriate.
All right.
Before he speaks, I just have one more moment, Your Honor. And I recognize everything that Mr. Ham is saying. I will say about the pending things in Tennessee, they seem to be what we would probably have as a almost Class C, except for the DWI, but them being pending since 2005 and him having been incarcerated all this time, I don't know what that means.
I don't know.
That's a
So,
long time.
we're not going to take that into consideration.
And I believe that is all I have.
All right. Mr. Galvez, do you understand from your previous experience in deportation and removal from the United States in 2009 and also in 2019, 2 separate times you were in the United States illegally and were removed from the United States and thereafter returned? Do you understand that the consequences of this case can and will most certainly adversely affect your ability and privilege to be in the United States because of this crime? Do you understand?
Yes.
All right. Do you wish to add anything in addition to what has been stated by the attorneys and what's in the pre-sentence report?
Algo que quiera añadir, aparte de lo que han dicho los abogados. Pues lo siento mucho y pues I'm really sorry. Y si el Señor me da la oportunidad de salir, the opportunity to be put in pondré todo de mi parte para ser una mejor persona. I'll do my utmost to become a better person. I'm profoundly sorry.
Do you understand, Mr. Galvez? You've got to do more than try hard to be the best person you can be. You have to follow the law.
Comprende, señor, que pues que es cuestión de, pues, no solo es cuestión de hacer el esfuerzo, sino que tiene que cumplir con la ley. Yes.
And you have committed this offense after being subjected to criminal charges here in the United States in the past, but on 2 separate occasions, you were deported, I guess, to Mexico?
Yes.
To Mexico 2 separate times. And then on the 3rd occasion, you illegally entered the United States and committed this crime. And to this day, you're still not a citizen of the United States. Is that correct?
That's right.
All right. Well, Americans welcome immigrants. That's what the United States is special for. My grandmother was Rodriguez, but her family immigrated in the lawful way and followed the law and the rules. We say welcome, bienvenidos, but don't make a mess. follow the rules.
No, sí, aquí en Estados Unidos le damos la bienvenida a los inmigrantes, pero también
In this case, you had been deported twice, came into the country
veces,
a third time and was not a citizen of the United States
regresó por tercera vez,
and committed this second degree felony
metió ese delito
of indecency with a child.
ante un menor.
And the pre-sentence report, which is in evidence,
Antes de la sentencia.
is very disturbing.
Sí, mire, caso, pues,
That you had sexual contact
contacto sexual
with a child 9 years of age,
de 9 años,
9 years of age.
9 años de edad.
And the pre-sentence report here states
Informe antes de la
that you were overheard
que a usted lo escucharon
on a phone call after that stating, I finally did what I wanted to do.
que dijo que al fin logró hacer lo que quiso hacer.
This was a statement
Esta es una
made by the child.
hecha por la misma.
No 9-year-old child
Ninguna niña de 9 años
should have to have
debería
their first sexual experience unwanted
sin
by you,
por una persona,
an adult.
un mayor de edad.
Shame on you.
Sí. Qué vergüenza.
You have pleaded guilty in this case voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted into evidence to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second degree felony of indecency with a child. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You must register as a sexual offender, and this will be for life. Failure to properly register as a sex offender in the state and in the United States can subject you to additional criminal charges. You will be required to immediately register, and that registration will need to be repeated and I think annually, and your attorney will help you understand how to fill that out. That needs to be done immediately. And this is the type of behavior, Mr. Galvez, that makes it hard on immigrants who want to come to America. Because unfortunately, criminal acts such as indecency with children punish people who are trying to lawfully immigrate into the United States. You hurt everyone, not only this 9-year-old child, yourself, the family, but other immigrants who want to lawfully come to America to search and try to reach for their dreams. We welcome immigrants. We are all a product of immigration. But don't come to the United States and take advantage of our welcome and commit crimes, especially sexual crimes against children. Shame on you. That is all.
Did he already fill out a registration form?
If we did that at the time of plea, Judge.
All right, then it is done.
So tell him that the judge mentioned we've already done.
That's the admonishment.
Okay.
Question in,
Need-